Do you like Mexican food? Hello, this is Reinhard von Hennigs. And if you do, you may know the franchise brand Chipotle. Whether you call that Mexican food or just not that good is a different question. Original Mexican food is definitely better. The reason why I'm musing about this company today is that they are involved in some litigation, and especially in New York, where a $150 million lawsuit was filed by workers in New York over what hundreds of thousands of violations may reflect to as a breach of employment law. New York law and the lawsuit cites the Fair Workweek law, which means you cannot change the employee's schedule without sufficient notice, without offering extra pay, and you cannot require employees to have consecutive work shifts without sufficient time in between. There is an 11-hour break requirement between different work shifts, and there is a 2-week in advance scheduling requirement. Most fast food restaurants cannot do that because their work shifts shift back and forth. Many companies cannot do it outside of the food industry. So the musing today is not only about what went wrong with this one company, but what can you do to avoid a similar liability. The so-called flagrant disregard for our laws, that's now Mayor Bill de-Blasio who mentioned that, is one part, but what can you do to avoid that you are subject to a similar lawsuit? The best way would be is to identify work schedules in advance, to identify changes of work schedule, to offer folks who are subjected to a work schedule change extra time off, extra compensation. And in a nutshell, it helps to check the law before you make HR decisions. In the meantime, you may wonder why Chipotle as a franchise company is subject to such a big lawsuit. The reason for that is that in New York, all 80 or 90 Chipotles are owned by the same company. So it's related to a big lawsuit with all of them. So it's not that each individual franchise owner is a problem here. It is a franchise owner for the whole city of New York.